This occasion is thus an important one for the judiciary, as it provides me with the opportunity to say a few words about the work we undertake and the operation of the law which affects our legal and judicial community. In this speech, I shall focus on two main areas that pertain to the administration of justice in Malaysia. Firstly, unity in upholding judicial independence and rule of law, and secondly, resilience in defending constitutional supremacy. As any new legal year begins, my thoughts turn to the principles at the heart of our legal system, in particular, judicial independence and the rule of law. These are not just ideals, but are core principles of our judicial and legal system which protect the public from harm and guarantee the principle of equity for all that underpins confidence in our judiciary. Judicial independence acquires greater significance in times of political, social, and economic upheaval. As the great philosopher Montesquieu once said, it is necessary from the very nature of things that power should be a check to power. In this nation where the keen instinct for justice is woven into the very fabric of our beloved country, it is important that the law is tested and seen by the people themselves to be serving their greatest good so that domestic legal order is assured. When I took office, I swore to uphold the rule of law and to defend the independence of the judiciary. It is a promise that I take extremely seriously. This important occasion serves as a reminder for the unwavering commitment of the courts to do right fearlessly. In the past year, the subject of judicial independence in our nation has drawn a fair amount of attention through critical observations and comments made against judgment of the courts and judges themselves. In the course of the legal system, cases with overtly political overtones will invariably find their way to the courts. Judges who preside over such cases are frequently subjected to a great deal of intense scrutiny in the media, especially social media. The decisions that they make in such cases are almost always criticized by members of various political parties and by members of the general public. I recognize the constitutional right of every citizen to criticize the judiciary and to test the correctness of its judgments through due process. Indeed, judges should be aware of public opinion, but they are not bound by it. Healthy attention and constructive comments towards the judiciary and its work are always to be welcomed, as they help us reflect on our work, improve to the best of our abilities and competence, and also remind us of the utmost importance of upholding judicial independence to maintain the rule of law. Thus, the criticisms that we receive should not result in disharmony between the judiciary and members of the bar, any political alliance, or the general public, but rather it should solidify and augment our determination to be even more united in upholding the independence of the judiciary and the rule of law. In this regard, when comments are not based on objective facts and rational arguments, let alone legally reasoned substantiations, but rather on surmises, political stances, or improper considerations, they are of no value to the advancement of the rule of law, nor do they help us to be united in upholding judicial independence. The acceptance of the court's judgments by the litigants and by the public at large hinges in part upon the transparency which the courts demonstrate in deciding cases. Only with transparency in its proceedings may the judiciary be able to earn and keep residual long-term public trust. In my opinion, a key component of transparency is accessibility. Lord Bingham, in his book, The Rule of Law, cautioned that the length, elaboration, and prolixity of some common law judgments can, in themselves, have the effect of making the law to some extent inaccessible. I would like to use this platform to remind my brother and sister judges to ensure that your grounds of judgment are clear, coherent, and concise because the target audience covers every possible sector. It is of utmost importance that our judgments be easily understood by the public as their impact in shaping the law of the nation is long-lasting. Not only that the judgments we write reflect our competence and diligence in carrying out the duties of our office. The grounds of judgments written by judges can be accessed online by the public. Such ease of access, I hope, translates into better comprehension of the judicial function. In this regard, I urge members of the public to read judgments in their entirety before forming an opinion and subjecting the judiciary to any form of vilification. At the same time, I would reiterate that judges make decisions and write judgments premised on the law and not on the notion of wanting to seek popularity. We write to keep the public abreast of the judicial function and not to seek validation from the public or from any quarters. If a judge decides a case premised on anything other than the law and or facts, then he makes a decision that is not sound in law, and in which case the judge fails to uphold judicial independence and the rule of law.